Good afternoon, everyone. My name is Jen Hicks. I'm the Director of Communications and Outreach with Maine Woodland Owners. We're a member organization that provides resources and expertise for folks in Maine who own woods and want to know more about how to take care of your woods, be the stewards, good stewards that everybody's interested in being. We have a website with lots of information, one of our and a monthly newsletter, and almost in about half of our newsletters we have legislative information because we have staff here at the organization that's very involved in keeping track of really important legislation in Maine and policies in Maine that affect woodland owners. And this has been yet another unusual, crazy legislative session that completed actually in July, which is quite late. And there are several bills of interest for the organization. So this program today is going to provide an overview, a wrap up of what happened during the legislative session and what is we're guessing is going to be happening at the second part of the session starting in January. It's a chance to hear the latest information. A lot of it's based on what was presented in the newsletter and what's on our website at mainewoodlandowners.org. And but there may be some more questions that people have beyond what was presented. So this is a great time to ask those questions. We have Tom Doak. He's the Executive Director of Maine Woodland Owners, and Karla Black. She's the Deputy Executive Director of Maine Woodland Owners. And so both of them have been very involved in legislative matters and are here to provide all the information you'd ever want to know about legislative session relating to woodland ownership. Okay, so on that note, again, this is a pretty casual program. I know that Tom and Karla will provide some overview of the different important bills. But after that, I think they're really interested in hearing your questions and finding out what kinds of clarifications you're interested in having and how you might be able to help get your voice heard about matters that we're finding to be really important for woodland owners. So who wants to start? Who wants the ball? Karla or Tom? Who wants this?
That would be me.
Okay.
So
thanks,
Jen. Again, I'm Karla Black. I'm the Deputy Executive Director here at Maine Woodland Owners, and part of my job is working with Tom on the legislative issues. So I have an update for you here today, and it's I've got quite a list of bills in front of me, bills that either we weighed in on or that we were just following. So I'll dive into those in a minute, but I did want to reiterate that if you have questions, please feel free to interrupt. You don't have to wait until the end as far as I'm concerned. You're welcome to put questions in the chat, and I'll try to keep an eye on that, or you're welcome to just unmute yourself and pose your question. But I'll try to keep, like I said, I'll try to keep an eye on the chat and see if you have questions in there. I think to start out, I'll just give you a little high-level overview of the session. I think Jen got it right when she said it was an unusual one. I think that's a generous term to describe this legislative session. It's the first session of the 131st legislature. It was a fairly new legislature, a lot of new legislators who had never served in public office before. They were off to a really slow start. They were printing bills that were coming out very slowly, and so things were taking a long time to get to committees for hearings and whatnot. Of the bills they printed for the session, there were 2,019 of them, which is a huge number of bills. And at the end of the session, they carried over 483 of those bills, which I think is close to 24%, which just seems like an unusually high number of bills to carry over. A lot of the bills that they carried over were bills that were on the appropriations table. And just to give you a little explanation there, bills go to the appropriations table if there's a fiscal note attached to them, and they have to have funding before they can be finally enacted. And it's highly unusual, and I don't know, Tom, I don't think you've seen it a lot either, that they carry over all of the bills that didn't make it for funding in this past session. So now, I forget what the number of those bills are, but it's significant that we'll just be waiting on the appropriations table to see if there's additional funding this session when the new legislature comes back into session in January. There were 234 concept drafts, which is a bill that is not fleshed out yet. It's just a concept, and that's how it is printed. I think that according to the statistics I've seen, that was the highest number of concept drafts in the last 4 legislatures. So those are really difficult to deal with because you often don't know what the real substance of the bill is going to be until you're actually at the public hearing. And as Jen mentioned, the session went really long. They had a statutory adjournment date of June 21st. And they didn't actually adjourn until July 26th. They seem to save a lot of their really big issues that had a lot of division. The Family Medical Leave Act, there were some tribal rights bills that they saved for the end of session. So they were here well over a month longer than they should have been, which is unusual. So that's just an overview of the session itself, and I'll dive right into the bills that we were following. And again, ask questions as we go along. The first set of bills that I wanted to talk about are the Sunday hunting bills, as you might imagine. These bills are really important to Maine Woodland owners and to our members. There were 4 Sunday hunting bills that were introduced this session. There were 2 related to youth hunting. There was 1 related to landowners being able to hunt on their own land. And there was 1 regarding hunting with a bow and arrow or crossbow. So we rallied the troops on those bills and put out calls to our members to contact their legislators and weigh in on the Sunday hunting bills. And our efforts really worked. Those bills came out of committee, all 4 of them came out with a strong 10-3 ought not to pass vote, which we were expecting, I think 9-4 maybe, but 10-3 was really great. And it was really helpful when you get a strong ought not to pass vote like that. It's really hard to overturn that on the floor. And so those bills went to the floor and they were all voted ought not to pass. So that was we were happy with that outcome, and we don't know what to expect in terms of the next legislative session. Typically you can't introduce the same bill that if you've already introduced it in the first session, you can't introduce it again in the second session. So they would have to come up with new concepts for Sunday hunting. So it's not impossible that they could do that. So it's possible we may see, another Sunday hunting bill, but not, we're not entirely sure whether we will or not. While we're talking about Sunday hunting, I just wanted to give a quick update on the lawsuit that's been pending. That was filed against the Commissioner of Inland Fisheries and Wildlife by a family that wants to hunt on Sundays. They claim that the new right to food constitutional amendment supersedes the commissioner's authority to enforce the Sunday hunting ban that's been on the books since 1883. That case was heard or presented in the Superior Court, and the judge dismissed it. And the plaintiffs appealed that to the law court. And that has been sitting in front of the law court, I believe, since before May. We filed an amicus brief in the case May 4th, I believe. And we're not entirely sure when that will be heard. The court could decide the case on the briefs, or it could schedule oral arguments. So we're keeping a close eye on that case to see what will happen. As I mentioned, we did file an amicus brief. to indicate what the impact of overturning the Sunday hunting ban would have on landowners, particularly that it would result in more land being posted. Does anyone have any questions about any of the bills or the lawsuit before we move forward? Richard?
Here we go. Sorry.
That's okay.
So relative to the lawsuit, is it unusual? I mean, there's a big backlog of cases. Why are they sitting on this? Any idea?
Yeah, I think that
Prerogative, I guess, but
I think the courts are really backed up in general.
okay.
So I don't know specifically what the caseload is like at the Supreme Court compared to what it normally is like, but I would suspect that there is backlog that they're trying to deal with. And we're just watching the schedule to see. They have oral arguments usually once a month. And September's have already been scheduled, so we're now keeping our eye on October to see if it might come up in that batch.
Thank you.
You're welcome. Any other questions or comments before we move on? All right. So I try to break out the remaining bills into some groups. And the first group of bills there, we saw there were two bills dealing with food sovereignty. The first bill, LD 1823, an act to respect and protect the right to food, was a very broad bill. It was very expansive and does many things, including allowing municipalities to enact local ordinances regarding what was called traditional foodways. And traditional foodways was included or defined in the bill to include hunting, gathering, fishing, and foraging. So essentially it would allow municipalities to enact local ordinances regarding hunting, gathering, fishing, and foraging. And the bill also prohibited the state from taking any enforcement action against any activities authorized by local food ordinances. The bill also had added two new definitions of the word harvest, which is interesting because that is the word that's at issue in the Sunday hunting lawsuit. Whether what harvest means, it's not defined in the constitutional amendment, the right to food constitutional amendment. So this bill sought to add a new definition for harvest in the IFNW and marine resources statutes that to include hunting, gathering, fishing, and foraging. So we testified in opposition to this bill at the public hearing on the basis that its far-reaching provisions could result in many unintended consequences for landowner rights and the regulation of wildlife resources. Specifically, we raised the issue of Sunday hunting. With this bill that allows ordinances concerning traditional foodways, would that mean that local municipalities could enact Sunday hunting ordinances? So the bill itself was tabled after the public hearing and it was carried over to the next session. So they haven't acted on it fully. I think they were responsive to making some changes that would have removed hunting, gathering, fishing, and foraging from the definition of traditional foodways, but we'll see when that comes back up for work session next session. The next was LD 1947, an act to amend the Maine Food Sovereignty Act. And that was very similar. The bill was nearly identical to LD 1823. It did not include the definitions of the word harvest that LD 1823 did include, though. This bill went through the committee process and was amended in committee and then amended again on the floor of the House to limit it to only doing two things. It amends the Maine Food Sovereignty Act by changing the definition of direct producer to consumer transactions. And it also states that a farmer's market may impose more stringent requirements on its sellers than those imposed by a municipal, plantation, or county ordinance. So it eliminated the issues that we were concerned about potentially allowing local ordinances concerning hunting, fishing, gathering, and foraging. And that bill was enacted into law without the governor's signature. Any questions about either of those? The next round of bills or next grouping of bills I have relate to tree growth and open space. The first is LD 1341, an act to amend the Maine tree growth law to encourage housing construction. This was a bill sponsored by Representative Ducharme, and the bill allowed the removal of one parcel of land per year from the tree growth tax law program for the purpose of new housing construction. The size of the parcel removed must be limited to the minimum lot size allowed by the jurisdiction, and construction must be completed within 2 years. If those conditions were met, the landowner would incur the lesser of the 2 tree growth tax law penalties. The constitutional minimum is what they would have incurred for a penalty versus the other higher calculation. The bill was in the taxation committee and it had a divided report out of committee. And the ought not to pass report was accepted in the House and Senate. And so the bill died at the, when it was presented on the House floor and Senate.
Karla, what's the constitutional minimum? I never heard of that one before. Is there's such a thing as a constitutional minimum penalty?
Yeah, I'm gonna let Tom take that one.
So the constitutional minimum penalty for any land, any property that comes out of a current use taxation program, so that's tree growth, open space, farmland, or working waterfront.
Yeah.
Is 5 years back taxes and interest on what you, so basically what you would have paid for over the last 5 years, and any interest on that money. That's the minimum penalty for taking land out of tree growth or any of the open space program by the Constitution. The legislature, and it has enacted a different penalty formula that is much higher. And the statute says you calculate both and the person has to pay the higher. So the constitutional amendment, the constitutional minimum essentially never goes into play because the penalty provisions are much higher. But you can't just get out of a current use taxation program in Maine without some penalty by the Constitution. Which is why when there are bills in that basically want to kick people out, you know, for whatever reason, and Karla's probably going to talk about one of those. You can't just let people out for free if you change the rules. You have to assess a penalty against them under the Constitution.
Thank you.
I have a question.
Sure.
It says, it also said something about one parcel per year. Is that one parcel per municipality, one parcel per county, one parcel per private landowner?
I think per landowner.
Okay.
And again, this bill did die during the session, so there's nothing more to come from this bill. The next one on my list is LD 1135, an act to ensure that carbon credits can be sold on forest land enrolled in the Maine tree growth tax law. This was our bill that was sponsored by Representative Boyle of Gorham, really to begin the discussion regarding the compatibility of the tree growth tax law program and participation in carbon sequestration programs. Our original thought when we put the bill forward was to perhaps make a statutory change to include carbon as a forest product in the tree growth tax law. But there was some discussion, I think, with Maine Forest Products Council and the Maine Forest Service, and we determined that a better first step would be to offer an amendment to the bill to create a resolve to have the Maine Forest Service and the Maine Revenue Services work together to update the tree growth tax law bulletin 19, which is a bulletin that explains in depth the requirements of the tree growth tax law. So to have them work together to update the bulletin to provide guidance on whether carbon sequestration programs are compatible with the tree growth tax law program. At the work session, when we discussed the issue of a resolve, the committee determined that they could reach that same outcome. Rather than moving forward with legislation, they could reach that same outcome by sending a committee letter to the Maine Forest Service and Maine Revenue Services, asking them to issue that guidance. And so that is what happened with that bill. They ultimately voted ought not to pass because they could reach the same result without having to move forward with legislation. And then, as Tom alluded to, there's LD 1685, an act to increase acreage eligibility and change requirements for filing plans under the Maine tree growth tax law. So this bill proposed to amend the tree growth tax law by increasing the acreage eligibility requirement from 10 to 25 acres and removing all parcels less than 25 acres. And so we strongly oppose this bill, and our reasoning on the acreage was that there had been a study commission convened by the taxation committee in 2018 that looked at the tree growth tax law and looked at issues and was looking specifically at whether any changes were needed. And they actually looked at the issue of the acreage requirement and determined that no change from the 10-acre eligibility requirement was necessary. So this bill sought to raise that eligibility from 10 to 25 acres and would have kicked anyone out that did not have less than 25 acres. It would have kicked anyone out that had less than 25 acres. And I think according to what Tom has explained, there would be a penalty associated with that because you can't get out of the program without some kind of penalty. The bill also it authorized municipal assessors to require a tree growth tax law plan to be filed with the town, and the town would keep it on record. And we thought this was unnecessary because there's already a requirement that landowners provide the tree growth tax law plan if required or if asked, and the town could keep it as long as possible. We also had concerns it indicated that the bill said that those plans would be kept confidential in the municipality's hands. And we had concerns with their ability to keep those documents confidential, given the number of the volume of them that they would have and whether they would have the ability to just physically keep them in a confidential manner. The taxation committee voted to carry that bill over. So that's a bill that we will see again this coming session. They'll probably start off with another work session on that bill to see where the taxation committee wants to move forward with that. Tom, do you have any other thoughts on where that might go?
No, I think this came from Maine Municipal Association, who thinks and they had an assessor who basically said you can't manage woodland if it's less than 25 acres. It's an unmanageable parcel of land, and that's not correct. In fact, we as an organization in a land trust have, I think, 8 or 10 parcels that are less than 25 acres, and we manage every one of them. So this was an attempt to just get a bunch of people out, and I think and somehow generate some revenue. So the problem is there were a lot of new people on the taxation committee, and it's a complicated law, and I think they just wanted to hold it over because they didn't have time to really work at it. So I think we can beat it, but we may need some help from the membership on this one, just to reiterate what this would do.
Great, thank you. And the next and last of the tree growth related bills was LD 1648, which is an act to make changes to the farm and open space tax law program. So it's the sister program to the tree growth tax law. And this bill would make a number of amendments to the farm and open space program to make the program more attractive to landowners and increase its public value and make it easier to understand and administer. The bill does a couple of things like removing the 15,000 acre cap, adding municipal reimbursement and creating a new valuation methodology. And this bill was also carried over by the taxation committee. The bill had been put forward by the Nature Conservancy, as well as others that had been part of a working group looking at the bill, including Maine Woodland Owners. So the Nature Conservancy is going to be leading a group to look at the bill and make some changes before the legislature reconvenes, because there had been some concern with the way that it was proposed. Tom, do you have more specifics on that? That one is.
I don't now, other than the open space law, unlike the tree growth tax law, has not been looked at for a very, very long time. These laws went into play were enacted in the early 70s, and tree growth has been reviewed and reviewed and reviewed. Open space is not, and it's clear there are some changes that should be made to the open space law to make it more, frankly, more attractive for landowners, because it's not a very, most people don't like the program. So I think there's a good chance something will happen, but there are a lot of competing forces on this one, and I have no idea where it will actually go. Yeah. We do have the Nature Conservancy has scheduled some meetings with a bunch of us to work on, see if we can come up with an agreement of some kind here to put forward next session.
Yeah, and that will be coming up very shortly. The next grouping of bills relate to forestry issues. The first one is LD 108, an act to establish a logger relations advocate within the Maine Forest Service. As it suggests, the bill would require the Maine Forest Service to establish a logger relations advocate to serve as a liaison to the public. We testified neither for nor against this bill based on the fact that we didn't know what the advocate position was, or why, what it would do, or why it was necessary. We felt the bill created an imbalance between stakeholders and favoring one stakeholder group over another with regard to interactions with the Maine Forest Service. The committee voted ought not to pass on that bill, and so the bill has died. The next bill is LD 180, an act to allow a person to file a paper copy of a timber harvest notification form. This bill allows the landowner or designated agent to submit a harvest notification form to the Maine Forest Service in electronic or paper copy. My understanding is that in 2021, the Maine Forest Service moved from paper filings into an electronic system in January, and didn't require the electronic filings to be mandatory until October of that year, and they provided some training on their website. They're still, even though they moved to an electronic system, they still allowed some filers who don't have the resources or capacity to file electronically to still receive assistance from the Forest Service in filing the paper version of the harvest notification form. We testified neither for nor against this bill. We suggested that there might be more the Forest Service could do to make it clear that help was available for those filers who needed assistance. We also suggested they could convene stakeholders to determine any shortcomings of the filing system. We thought it wasn't in the interest of anyone to move backward and to go back to a paper filing system, but that the right resolution was to find a solution that worked for everyone.
Karla, there's in my limited experience, there's still paper hanging on a tree at a logging site. Has that been eliminated? You know, some kind of a permit usually gets attached under plastic with a tape on a tree. What does this have to do with electronic filing? Anything? Is that no longer necessary?
I think those are still required to be hung on a tree at a harvest system. But Tom, what do you?
Right, that's right. If when you file it electronically, you get back something that you can post. Okay. Instead of filing a paper copy that's one is attached on the back. And the whole idea is just to make sure that the posting is so that a ranger will know this property, this one has been notified is going underway. And it's actually a good thing for most landowners to have that, so. You know,
But
this,
posting is still required.
yes, posting of that notice on the site. Principally in the log yard is still required, as is having a number associated with that posting on all wood that goes down a highway. And it's partly to protect the landowner to be able to track wood, where did this wood come from? And in case some of it gets misdirected.
So that bill, the committee voted ought not to pass, and that bill is dead as well. The majority of the committee did decide to send a letter to the director of the Forest Service to encourage her to continue to work with filers, especially those who are struggling with the online process. The next bill is LD 993, an act to facilitate stakeholder input regarding forest policy in Maine. This bill started out creating I think 21 member board that would provide guidance and input to the Forest Service. And it got some pushback. We opposed the bill. The bill was amended after the public hearing to pare that board down to 11 members. It originally had been, the members were to be appointed by the governor, the president of the Senate, the Speaker of the House, and people thought that was too unwieldy, so the amendment made the appointments just by the governor only. And the purpose of the board would be to help the Forest Service with the development and implementation of the State Forest Action Plan and advise the Bureau on a variety of other issues. Oh, sorry, we have someone joining us. Hold on one second. Thank you. Again, we opposed the bill, but it was passed to be enacted in the House and passed to be engrossed in the Senate and was there after placed on the special appropriations table by the Appropriations Committee. I think it has a fiscal note of about $5,000 a year, but it was not funded during the Appropriations Committee's deliberations during the last session. So it is one of those bills that's been carried over to sit on the special appropriations table. So it's hard to know what they'll find funding for in the next during the next session. But this one does not have a very high fiscal note, so I think it's possible that it could move forward. Tom, did you want to say something?
It's also a bill that the governor vetoed last session and has not been favorable, looking at it favorably. So even if it's funded on the appropriations process, the governor has a chance at it to veto it, and I would be very surprised if she wouldn't veto it. So, and she's never had a veto overridden, so I think it's probably if she vetoes it.
Yeah. The next bill is LD 1048, an act regarding the authority of municipalities to regulate timber harvesting. This was also our bill that was brought forward by Senator Black. This bill has a long history. It started out in the 130th legislature as a resolve that required the Maine Forest Service to conduct a stakeholder group to look at the issues of municipal enactment or adoption of timber harvesting ordinances. And the stakeholder group brought forward recommendations during the second legislative session that were turned by the committee into a committee bill that would implement the stakeholder recommendations. And that bill was died at the end of that session pending reference to committee. So it never even received a reference to committee to have a public hearing. So we brought it back again. Like I said, it's a result of the stakeholder group. And what we know from the report of the stakeholder group, again, this bill was the same recommendations that were in the bill last session. What we know from the stakeholder group is that very few municipalities have followed the process requirements in the law. So this bill would establish new timelines for municipalities to come into compliance with the process requirements for adopting or amending timber harvesting ordinances. The bill received great support in committee. Everyone testified in favor, except there was Mofka, I believe, testified neither for nor against. There was no opposition to the bill. The committee made one minor amendment to the bill and voted ought to pass as amended. And the bill received a preliminary vote in the Senate and then was placed on the Senate's unfinished business, where it sat from April until the end of session. So the bill was never brought forward again for another vote. So it died at the end of the session on the unfinished business calendar. Tom, do you want to say more about that one?
Well, I don't think I've ever seen a unanimous committee vote on a bill sit for 3 months and then be killed off without ever having the chance to even vote on it this was not a controversial bill. Essentially, municipalities have adopted ordinances in violation of the statute that outlines what the procedure they have to use in order to adopt an ordinance. So we were trying to clean that all up. Even the Maine Municipal Association is supporting of this bill because they know there's a problem and we're trying to all solve it. But we could not get the presiding officer to bring the bill. He would not allow a vote on the bill. And by doing that, as Karla said, when they adjourn, if it sits there on unfinished business and hasn't been held over, it automatically goes poof, and that's what happened. And I've never seen this happen before. I mean, Richard was in the legislature for 16 years. Sometimes that would be used to kill off a controversial bill, but not a unanimous committee vote. So
Do we know why the Senate president has never indicated why he did this?
I have my suspicions, but I did meet with him. I spent an hour with him on this issue and went through the whole bill with him, explained what it did, what it didn't do, and everything. He never would say definitively what his issue was. I suspect there are towns that have adopted ordinances that don't want them would probably not want them anymore if it came to their attention that they've got an ordinance that isn't legally adopted. The problem becomes now for landowners is can the town enforce it? Is the town going to enforce an ordinance that isn't legally adopted? And where does that fall? And that's what we're trying to solve. So we're going to have to fix this at some point. We'll just keep bringing the bill back. It will happen. It will get fixed at some point.
And as we talked about with the Sunday hunting bills, we can't generally bring this bill back next session. You can't bring a bill with the same issue back after it's been presented in one session. So we'll have to wait until the 132nd legislature if we want to bring the bill back.
And the president of the Senate will be term limited at that point too.
Right. That's the most important piece of that information. The next bill is a resolution proposing an amendment to the Constitution of Maine to establish a right to a clean and healthy environment. This was LD 928. So what it does is it grants this right to, and I'll read it to you, a clean and healthy environment and to the preservation of the natural, cultural, and healthful qualities of the environment. So that it creates this new right in the Constitution for individuals to a clean and healthy environment. We testified in opposition, given the uncertainty of what this bill actually means and what the implications of it would have. Given our experience with the right to food constitutional amendment, we were very concerned that this bill would end up in litigation. given that it's not well defined in terms of what any of that actually means. The bill was carried over by the legislature, so we'll see it again next session and see what happens to it. Just of interest, there is a similar constitutional provision in Montana. And there was a group of youth that brought a court case in Montana against the state for violating that provision of the Constitution by promoting fossil fuel energy policies. And the case went to trial in June, and the judge recently ruled in the plaintiff's favor. So, you know, there is developing some precedent out there about similar provisions in other states. The next category I have is roads. There was LD 461, an act regarding private roads. This was a confusing bill that was brought that sought to clarify the definition of a private way to equal a public easement and create a new definition of private roads. It also required municipalities to establish standards for private road construction and had other changes related to private road associations concerning repairs and maintenance. The bill was significantly amended, and as it is enacted, it it includes those changes related to the private road associations regarding repairs and maintenance. And it also requires the Abandoned and Discontinued Roads Commission to review the terms private way, private road, and public easement, and report back to the committee in January whether changes to current law would improve understanding and use of these terms throughout the Maine revised statutes. The Abandoned and Discontinued Roads Commission has started that work, and it's stunning the number of times those words appear in Maine statute and how different some of the meanings they have are. So I think there's a significant amount of work that the commission will have to do in order to report back to the state and local government committee with its recommendations concerning how to make those less confusing and how to make the definitions more consistent.
Do we have a seat at that table?
We do. I'm on the commission.
It's good. Thank you.
Lucky me.
Yeah.
The next grouping of bills regarding wildlife. There was LD 614, an act to provide free antlerless deer permits to certain landowners who allow the public to hunt on their property. So this bill amends the law to provide an antlerless deer permit at no cost for all eligible landowners who apply for a permit and keep their lands open to hunting by the public. My understanding is that recently Tom, you may have to jump in here and save me describing this, but my understanding is that recently the process changed for antlerless deer permits and that a lottery was created. And the commissioner was required under the lottery to issue 25% of the permits in a wildlife management district to landowners. And the requirement is if they were chosen in the lottery, they were still required to pay a $12 permit fee and I think a $2 agent fee. And I think there was some discontent with the change to the new process, and that prompted this bill to go back to provide free permits to landowners who keep their lands open to hunting by the public. Did I get that right? Okay.
Yes, you have it right.
Okay, good. So we testified in favor of the bill, but presented the committee with a proposed amendment that would keep the lottery system in place, but would waive the $12 fee for those landowners selected in the lottery. The IF&W committee requested to carry this bill over for additional consideration next session. I think they were hoping to hear from the Department of Inland Fisheries and Wildlife how the process went during this most recent lottery issuance of lottery permits. And so we'll see when they report back. I think they have a report back on this to the committee, so we'll see how that goes and where the committee's inclined to go with this.
Carla, these permits, they're not transferable to anybody, right? You get a permit, you're a landowner, you get a free permit. You're the only one that can shoot the deer, right?
I'm gonna defer to Tom on that. I would guess yes, but
Yes, yes, it's to the individual. It's to the individual, and you can buy it's called the any deer or doe permit. You can buy one, and it's for you yourself. Yes, yes.
The free permit is not any different as to who's eligible to take a deer then.
It's every permit has limited to that person whose ever name is on that permit. The whole idea is the redoing the whole system was they really want to get the deer harvest up, and particularly the antlerless deer or the doe population down because there are so many deer. And they actually, for the first time in a long time last year, met their goal, and it was the highest deer kill in the history of the state of Maine last year, using this new system. So that I think the legislature was saying, we may have it pretty right here. We don't want to mess it up too bad until we have a little more experience with how does this system working, because they're finally getting to the goal of trying to push that deer population down, and particularly in the parts of the state where there are way too many deer.
all right. The next bill under wildlife is LD 57, an act to amend Maine's endangered and threatened species list. And I'll read to you the changes that were made to the endangered and threatened species list. The bill removed the box turtle and the Rapids clubtail from the endangered species list. It added the Ashton's cuckoo bumblebee and the salt marsh sparrow to the endangered species list. It adds the bank swallow, the Bicknell's thrush, the blackpoll warbler, the cliff swallow, the margin tiger beetle, and the tricolored bat to the threatened species list. It also made some taxonomic nomenclature changes to the list as it exists. The one thing that they amended the bill to do was to require the commissioner to report back to the IF&W committee no less frequently than every 4 years on any recommendations she might have regarding status updates or changes to the species designated as endangered or threatened. And we supported this bill. And the last bill I have is about snowmobiles. The bill is LD 732, an act to prohibit off-trail operation of a snowmobile in an area closed to off-trail operation. The bill prohibits a person from operating a snowmobile off-trail or off a snowmobile trail identified by the Department of Agriculture, Conservation, and Forestry as having been funded by the Snowmobile Trail Fund. If the trail is posted as being closed to off-trail snowmobile operation and the operator has not obtained the permission of the applicable landowner or landowner's representative. So I think it relates to trails that have been designated as being funded by the Trail Fund. And if those are marked, you cannot operate off them. If you do, you might be subject to a civil fine of not less than $100 and not more than $500. It does create a Class E crime if there are more than 3 violations in the last 5 years. And we testified in support of this bill. And the bill became law and will take effect when the bills take effect on October 25th of 23. So it'll be in place for this winter season. And those are.
Carla, I might add that
Yeah.
this is so in Maine, you do not have to have permission to ride a snowmobile on someone's land. I mean, you can't if they tell you can't or it's posted, but it's assumed you can go on someone's land with a snowmobile unless you're told otherwise. And that started to be a big problem of people leaving the designated trails that the state has, major snowmobile trail systems, and just going willy-nilly. And so instead of requiring all permission for snowmobilings like you have for ATVs, kind of the compromise was if the trail is marked or signed, you cannot leave the trail or it's a violation, then it is a violation if you leave. And it's not a trespass situation that it's a violation of operating a snowmobile. And any law enforcement officer can enforce it, and it doesn't require the landowner to be involved at all and say, gee, I didn't give permission, or I want you prosecuted. You violate, if you leave the designated trail and there's that sign there, you will be summoned for, illegal operation of a snowmobile. And that is something the Warden Service thought would solve a lot of their issues they're having with off-trail riding and causing problems. So we'll see how it goes. But the Snowmobile Association was actually the organization that actually brought this bill forward and supported it.
Yeah.
So.
Tom, did I miss anything? Is there anything else you wanted to
Nope.
add?
No, the only thing I'll add is I hope the folks that are on there just get a sense, not necessarily the details of any of these bills, unless you have a real keen interest, but you can see hopefully get appreciation for the nuances of dealing with some of these bills and some of the things we have to deal with, and the very broad range of things. I know Richard, being in the legislature for 16 years, probably understands this, but you just never know where some of these bills are gonna go. And some that don't look like they're going to be a problem at all end up being that, and some that look like they are going to be an issue, they get amended to the point where it doesn't even come close to affecting landowners. So there's quite a variety of things, and there's just a lot of time spent to try to keep a handle on a lot of these. So there's a lot of other bills that we followed that for one reason or other thought they'd be important, and they may not have turned out to be. Right.
I think I had a list of close to 70 bills that we were either monitoring or actively involved in. I think that it was close to 70 total that we were involved in some fashion.
The other I think difficult thing for us in the upcoming session is, with all these bills held over, I've never seen 400 some bills. Did you say, Karla?
483, I think.
I've never seen anywhere near that number. The problem is those have probably all had a public hearing, and that is our only guaranteed chance to be involved in them. And they probably all had a work session. So there's nothing that would prevent the committee from just acting on them just at any time they want to act on them and pass them or drop them. And you don't necessarily have any ability to comment to a committee on these when they're doing that, the status they're in. So I've never seen that. So there's going to be a lot of behind the scenes work with the committee members to try to get recognized that if they're starting to vote on a bill that we care about, so that we get a chance to speak in front of the committee. And that's going to be a real big change in this upcoming session.
And they could get to work on those right off the bat. So it may be a fast starting session this time around.
They could bring up a bill. They could bring up a dozen bills that you don't know they're going to bring up, and then vote on them right there without you knowing they're there.
Yeah. I know I went fast through some of these, and I'm sorry if I caused any confusion or anything. If I did, please feel free to reach out to me directly. I'm happy to answer any questions or talk more about the legislative process if you have any questions about that. I know Tom and I would both be happy to take those calls and answer any questions you might have if you haven't had a chance to ask them this afternoon. And I think unless there's any other questions, I think we are ready to wrap up.
I'd say we're looking at the number of people dropping off. I think we're set.
Yeah, I think we're set. So thank you all for joining us.
Good to see you, Richard.
Thank you very much.
You're
Thank
welcome.
you.
You're welcome.